All right. Hello, everyone, and Happy New Year. I am so excited to be back with this incredible group. You all know that this is the third of four sessions that we're having to talk about intellectual property protections. So, we spent some time talking about the fundamentals. We also talked about the power of partnership, and that included not only legal partnership, but also a ton of free resources that the USPTO offers. So today we're going to continue the conversation and speak about success stories as well as how to maintain your intellectual property registrations, because that is equally as important as the initial application process. So I have some esteemed guests on the panel with me. I'm going to let them introduce themselves because I think it's easier for them to talk about themselves than for me to summarize their incredible bios. So we're going to start with Elizabeth, and then we're going to move to Xavier, Tara, and then finally Stephen. Elizabeth?
Well, thanks so much. And it's a pleasure to be back with you again today. My name is Elizabeth Dougherty. I'm a 30 plus year veteran of the US Patent and Trademark Office. I currently serve in the role of Northeast Regional Outreach Director, which, as I like to say, is a very long way of saying that I help people. My team and I engage with stakeholders throughout the entirety of the East Coast of the United States, and that's stakeholders from all walks of life, whether independent inventors, individual business owners, large industry, colleges and universities, anyone who's interested to know more about the role and importance of intellectual property. We're here for you.
Thanks, Elizabeth. Xavier?
Thanks for having me back. So my name is Xavier Haley. I'm an intellectual property attorney. I specialize in areas of patents, trademarks, and copyrights. So my technical background is actually chemical engineering, but I work for different types of softwares, different types of patent applications dealing with software applications, dealing with battery technology, and so forth. Also work with entrepreneurs and inventors to protect the IP. So for example, on the trademark side, on the patent side, and the copyright side. So I love working with individuals and small startup companies to guide them through the intellectual property process because there's a lot of things they do not know.
Thank you, Tara.
Well, hello, Tara. And I do not like introducing myself, but relevant to today's topic, I am a entrepreneur who hires people like Xavier to do my trademark. I just recently had the term success bullying trademark, and that comes from my work that I do for women all around the globe. And I'm very excited about that. I'm very excited to be participating on today's panel, hopefully to encourage everyone listening in to go ahead and get your name, title, whatever it is that you need to get trademark, get it done, and take the easy route. Go with an attorney. I am not an attorney, but I hired one.
Thank you for making sure to say that. We talked about that in the last session and we're going to get into it again. Great advice, though. All right. Last but certainly not least, Stephen.
Good morning, everyone. Great to be back again. My name is Steve Shape. I am an intellectual property attorney. I've practiced patents, copyrights, trademarks, and trade secret and other areas of intellectual property for going on now 40 years. So have quite a bit of experience in the space and certainly want to assist anyone here online and provide whatever information is necessary in order to be able to understand intellectual property as well as protect your rights and making sure your business can flourish.
Absolutely. Thank you all so much. And I'm so happy you said that last part, Stephen, because you're absolutely right. A lot of what we're talking about, the main purpose is to make sure that the business can flourish. So I'm going to talk a little bit about that to get us started. I just have a few quick slides and then we're going to slide right into hearing from the experts because I know that that's the part that everyone is waiting on. So let me share my screen. And I'm assuming that you all are seeing a presentation. Is that correct? Yes, perfect. Thank you. All right. So again, we're continuing the conversation about intellectual property protections. And I wanted to make sure that we left space to talk about successes because it is a process. It's not something that happens in a couple days, weeks. It takes months sometimes to be able to make sure that you're filling out all the right paperwork, securing the right information, etc. And so I wanted you all to hear from folks who had done it successfully and from experts who have helped people like yourself successfully file. So the first thing I want to bring up is remembering your why. We talked about this in the very first session, and it's even more important now. You're not just doing this for no reason. You are doing this to build generational wealth. So when we think about some of the most incredible intellectual property that we love in the world, it may have been built a couple years ago, but a lot of things were built in some cases centuries ago. And so their families, their employees, all the people that they love are still able to thrive off of one incredible invention. And so you're also building because you want to scale to a multi-million dollar business. Scaling requires a lot of thought and intentionality. Again, we talked about that in the first session, but that's a huge part of why we want to protect it, because there are financial benefits to being the owner of intellectual property, just like there are benefits if you owned physical and tangible assets. And finally, you want to be able to thrive in the knowledge economy. The key word in the knowledge economy is knowledge. So, what we know, what we create, what comes from our heart and our mind, that is our currency. And protecting your intellectual property is one of the most important steps that you can take to be able to thrive. So, when you think about the whys, those three, they require consideration. And so, just four considerations I want you to think about. The first one is organization. When you are going through the intellectual property protection process, whoa, that's a lot of P's. The first thing you want to do is get organized. Get informed first through the free resources that the USPTO offers. We talked at length in the last session about all the amazing resources and information that is on the USPTO's website, and I'll drop a link there in the chat in just 1 second. But I also want you all to be clear about the fact that you can get information through hearing other people's stories as well. The goal here is to be able to help you make informed decisions at every step of the process. The second thing I want you to think about with organization is drafting a strategic plan. And I know that Tamika and Elizabeth talked about this extensively in sessions 1 and 2. You want to think about the types. So, how you layer your protections. Do you need a patent and a trademark? Do you need a trademark and a copyright? What are those things and those layers that you need to gain full protection? You also want to think about your classes. So I mentioned in some of the earlier sessions about my process for choosing the classes, because I offer a number of different services. And so when I was making my class selections in partnership with my trademark attorney, we talked about which class would give me the widest protection to start. And then as I built and scaled my business, we could add on classes, or if I wanted to file for multiple classes right away so that I could have the widest protection to start. There is no right or wrong answer. It's just about how you create your plan. And then finally, you want to think about your filing schedule. Let's be honest, this stuff is not free. And so you may want to scale out how you set up your filings, how you set up your protection plan, because you may want to upload or front load, excuse me, some applications now, wait a little bit, perhaps get some more revenue, some more cash flow in the business, and then pay for others later in the year. Again, there's no right or wrong answer, but that organization is going to help you make a great decision. And then you want to pay attention. So, of course, IP protection is a legal process, so you do have to watch out for a few things. The first thing is that you want to set aside time to make sure that you are thoroughly and accurately completing forms. I cannot stress enough, this is where having an attorney is so important, because I'm not an attorney. Tara mentioned she's not an attorney. It's a lot of legalese, right? And unless you want to hurry up and try to go to law school just to file this application, which you probably don't, this is where that partnership becomes so important, because again, these are legal documents. So you want to make sure that you fill things out appropriately the first time, because when you have to make what's called substantive changes, that costs money to have to refile things and make these changes. You also want to research when in doubt and research when you think you're sure. So every step of the way, make sure that you're making those informed decisions, regardless of what you think that you know. And then finally, make sure that you respond meticulously but also promptly. So some things are time sensitive. And so you want to make sure that you're not letting things lag out and emails, sit out somewhere for months at a time. Be meticulous in your response. So if you need to do some research, if you need to schedule time with an attorney, do that. But you should be using your best judgment in how you space out those actions, because prompt responses will only help your situation. And so then two more considerations. First is partnership. We cannot stress this enough. Secure legal partners early if you're going to use them. So the best time to get an attorney is before you start the process. The best time to get an attorney is in the process. The best time to get an attorney is at any point in the process. But I can't stress enough how important it is to try to get an attorney early, because they can help you make better decisions. There are some things that I thought I wanted to do. And when I sat with my attorney and we created my strategic plan, I was like, okay, no, I need to do this instead. I'll take this action first, then this one. Here's the order that I file my trademarks, etc. They can only help. And so then you also want to review the USPTO's resources for clarity. So I know for some of us, it's not necessarily that we're hyper independent, but we just like to be informed when we come into partnerships, which I totally appreciate and understand. So if you want to do your research first, take some notes, and then come to your legal partner with the information that you found, feel free to do that. That makes sense. Partnerships work best when everyone is fully involved. And so there are two resources that the USPTO offers that I think will be particularly helpful. And we've talked about them in the first and second session. The first is to visit the Learning Resources page. Again, I'm going to drop it in the chat shortly. The second resource is actually the USPTO's Patent and Trademark Resource Centers. So these are in person opportunities for you to go to at local libraries. And also, you can find them on the USPTO's website. I'll drop the link in the chat where you can find a resource center near you. Last but certainly not least, optimism. Optimistic, how can I put this? You have to believe that your crazy idea is like a once in a lifetime chance. So when I first started filing my trademarks, at first I was like, I can't believe I'm doing this. Does my work even matter? Does my company name even matter? But the excitement that I felt knowing that I had something that was worth protecting was, I mean, it was just immeasurable. It was so exciting to me to think that this little girl in my head, I was seeing little me could create something that I want to put that C, right, with the circle around it, or the TM, or the R with the circle around it. So remind yourself that your creativity is worth protecting. Second, create a use plan. Some of what holds us back from making the decision to protect our intellectual property is that we don't know what we're going to do with it. And this is also important when you're thinking about filing, because you may file under intend to use. And so you do have to have a strategy ready, because that's time bound. So, how do you plan to use it? Are you going to launch a new business, start a new product, start a new business, launch a new product or service? Or are you going to create something within 6 months, 3 months, 12 months? Get your use plan together, because that'll help keep you motivated throughout the process. And last but not least, celebrate each step. When I used to get those emails forwarded to me from my attorney that said, yes, you've been assigned an examiner, this is gone to publication, I would be like screaming in my office because I was so excited, especially that first time, because every step meant that number one, not only had I made the right decision, but I had the right partner so that it was able to flow seamlessly, and I was closer to protecting my creative work. So again, that optimism is going to be critical because it is not a quick process. There's a lot of moving pieces, but optimism is going to help see you through to the very end. So those are the considerations that I had. I want to hop right into our panel discussion. I'm so excited for you all to hear from our four panelists. Again, here are their names so that you can have them. And just like before, I'll make sure to drop links to how you can get in touch with them in the comments on YouTube and on LinkedIn. So Xavier, Tara, Stephen, and Elizabeth, thank you again for joining us. So happy to have you here. I'm going to hop right into the questions. So you're going to see me looking over here for a quick second. So I want to start with the first question, which is what aspects of successful IP protection applications do you think require the most consideration? I want to start with Elizabeth for this question, and then I'm going to move to Stephen, then Xavier, then Tara. Elizabeth?
Oh, well, thank you, Kaylin, and thank you for that question. There's so many ways to answer this that I almost don't know where to start, but I'm going to start with um, preparation. Preparation and education. And it's something we've touched on in the first two episodes of your series. Because all too often we see people who are mixing up the various forms of intellectual property, patents, trademarks, copyrights, trade secrets, and they may seek to go about the wrong type of protection for what it is they're trying to protect. So I think people really need to first take a step back before rushing into engaging with the USPTO or engaging with the US Copyright Office or even engaging with an attorney to first become that best educated consumer that they can be. It's something that we do before we hire a plumber or an electrician. We do our homework. We look online, we ask our colleagues, we ask our friends, we now, I'm not saying you should share your idea openly and widely and freely, but investigate what it is you are seeking to pursue. And this is where, again, the USPTO website, which you've referenced several times, thank you very, very much, and that learning and resources pull down tab especially, um, that individuals should educate themselves as to what they are trying to protect, what they are trying to undertake. Use our IP identifier tool that's available on our website. So education is one of the first aspects that I think people need to take a moment, take a step back, and analyze. But then the preparation of their materials. Again, before engaging with an intellectual property professional, whether it's a patent attorney, patent agent, trademark attorney, copyright attorney, prepare your materials. Don't just go in with a kernel of an idea. In some way, shape, or form, at least to the best of your ability, document what it is you are trying to do. And this goes, Kaylin, also to your idea of building a plan. Building that plan, even if you're not entirely sure of the terms and the exact, parameters of what it is you've invented or created or developed, um, get something down on paper. So when you're having those first and initial conversations, you have something to show, something to share. So I really think education and preparation are two aspects for success. And then, of course, all of the things that you've just referenced in your considerations. And thank you for laying that out so beautifully. The four different considerations of organizing, attention, partnership, and optimism. That last one being so critically important that we believe in ourselves. So that would be my quick answer to your question.
Thank you so much, Stephen.
So to kind of expand a little bit on what Elizabeth and what Kaylin both said, and thank you very much for those wonderful thoughts. Certainly, clear identification of your intellectual property is so important. Trademarks that are distinctive, unique, not generic or descriptive, are extremely important to identify and use early on. Um, Certainly, the legal protection. There's U.S. law, and then there's international law. So you need to consider if you want just U.S. protection, and is that going to be enough to be able to address your marketplace? Because that's really what this is all about: is protecting your intellectual property in the marketplaces in which you're going to do business. Um, Part of this also would be including starting the process. Certainly, a comprehensive search is really necessary. You need to accurately describe your intellectual property, as Elizabeth mentioned. Puts things down in writing. When it comes to trademarks, identify what your goods are, what your services are. When it comes to patents, make sure that you are identifying what your invention is. Include drawings when you can. And then, of course, preparing and putting all this together to begin the application process. Certainly, as Kaylin suggested, you can try to go this on your own, but it's probably better off to left to somebody who does it on a regular basis and has all the full understanding of the nuances. So I think those are kind of maybe a little bit more detail about some of the things that we've been discussing here so far today. So I'll go ahead and turn it over to.
Thank you, Xavier.
So I would piggyback on what they said. I agree 100%. So one thing I tell clients all the time, look at this process as business first, and the legal's there to support what you're trying to do. It's not the other way around. Legal is not pushing what you're trying to do. So you have to come with your what you want to do in terms from a business standpoint. If you have a product, let's say educational course, and you want to provide like, okay, what's your time frame? As everybody talk about, when you are you planning to have that out? So you can kind of gauge on from a trademark standpoint when to file the application. If you're already using it, let's do a 1A, which is known as a use in commerce, or if you plan to use it in the future, it's a 1B. On the patent side, there's things that you can do that can actually prohibit you from obtaining the patent in the United States or overseas in other countries. So it's best to engage a patent attorney ahead of time because you just don't know. For example, if you're already using the product, your invention idea, you might be barred from obtaining a patent in, say, Europe. Or if you're already using it longer than a year, be barred in the United States. So there's things that have to be done ahead of time for what you want to do. So as everybody mentioned, it's best to actually have preparation knowledge. Second, engage somebody who knows what they're doing so they can guide you before you actually may do something that prohibit you from obtaining your intellectual property rights.
Thank you for that advice, Tara.
Obviously, everything that everyone has said thus far is spot on and it's accurate. And to piggyback, because I did hire an attorney, I did still do homework before I hired my attorney. And I had to know, what is my vision? How do I see this term success bullying unfolding? What is my purpose? How do I want to empower or impact the marketplace with my thought, with what I created? And so I cannot speak enough to having a vision for that thing that you are creating. Where are you going with this? I'm a firm believer that when you know where you're going, you can get there. Your knowing is your GPS. And so you know how to have an intelligent conversation with your attorney when your attorney is saying, okay, are you planning on just using this in the US? Or in my case, do you plan on using it abroad? Because I do a lot of work throughout Europe, the Caribbean, Canada, and throughout the Africa. So it's very key that you do the homework, you have in-depth conversations with yourself, you know what your vision is so that you can articulate that to a professional who can best represent you.
I appreciate what you all have said so much. And that's why I put optimism, because at first I was like, oh, I'll just put the nuts and bolts. But I'm like, no, people have to believe in what they're doing because, to Tara's point, you might only be in business in your local community to start, but you could have something that goes around the world. So you need to plan for that now because, like Xavier was saying, there are time limits on things. So if you have a patent, let's say I'll take a product that I know is already in the marketplace. I think it was either Taraji P. Henson or Tracy Ellis Ross. They have an attachment to their bottles that allows the product to spread like on their I think it's Tracy Ellis Ross, but like with the hair care product. And that's such a cool attachment, right? It seems very simple, but if you're a person who has very thick or very curly hair, you already know it's hard to get things like to your scalp. That product, what if they had just said, oh, I just want to launch this just for, like, women with thick hair in the United States? Then they could have been in business for a year, thought of that attachment. Like Xavier said, it might have been too late for them to get a patent for that particular attachment if they have one. If they don't, I hope they do take that and patent that. But you do have to have a long term vision. You have to be excited about what you're doing, and then you have to think about the how wide you want it to go. So this is where the classes become important, because you might have a class filing for, let's say, just consulting services or educational services, but that might flip and turn into books, downloadable content, merchandise, all kinds of things. So having that legal partnership, especially somebody that you trust and that is equally as excited about your invention and your creative work as you are, they can help you go the distance with that to make it worth the process. All right. So, second question, get my life back together, go back to my question. So, the second question is, can you all tell us about founders and creators who had a successful filing after navigating office actions or filing rejections? How did they resolve the issue? So this is where somebody gets the office action, they got to fix some stuff, they got to provide a response, but it ended up turning into a successful filing after those office actions. Can you tell us what are some ways that they resolved it? What are some successful steps that you've seen founders and creators take? I'll start with Stephen for this one, and then go to Elizabeth, Xavier, and then finally Tara. I'd like to hear your perspective on the process for
Oh,
you.
because I was ready to answer that
I
one.
know. Don't worry, I'm gonna get it because I want to hear it. I know. Stephen, we gonna start with you.
Great. So yes, an example that I have is an inventor and an applicant that was interested in obtaining an unusual trademark. It was trademark for a particular color used on a fastener. This particular individual had a very significant company. He represented and did a lot of work with the automotive industry. But this color blue was very particular for his use in that it identified his product and identified his brand. Um, Back when we were doing this, color was not an option, right? You really didn't have the ability to trademark a color, and we had to work through a significant amount of office actions. We had to, clarify many parts of the application. We had to maybe change the scope of the application itself by way of goods, by way of the mark itself. When you have colors, you have specific color parameters that you have to identify. And so all of these things were crafted into legal arguments in responses to objections to highlight the uniqueness and provide evidence for the trademark examiner to identify the fact that this was in fact a unique trademark that could be identifying goods for our client. Those kinds of things are very important when you move forward in the process to be able to address all of the particulars of a given office action and then successfully argue and craft arguments to be able to overcome those objections. Hopefully that's helpful.
It was. Hold on. Let me hop in real quick, Xavier. I'm so happy that you gave that exact example because I just saw a video on YouTube about someone with this particular shade of blue. I'm going to find it and I'll put it in the comments for this because it was fascinating to me. But I love the fact that that person believed enough in this thing that would have seemed impossible to start to be like, no, I'm still going to pursue it and I'm going to go the distance. And I love that as a legal partner, right? You and the people who are working with this person were able to say, no, we're gonna figure this out, right? There is a way that we can try to figure this out, and we're gonna exhaust all options to try to help you protect your creativity.
And what was unique about this, just so you
Yes,
know, is that this was really the first time, and this is
yes,
back some years ago now. I'm sure Elizabeth can comment on this, but color is obviously something that's become very interesting from a trademark perspective. But this was kind of like the first blush activity, and so it took a significant amount of time, but it was well worth all of the activity and even the expense that incurred in order to be able to obtain that trademark because it ultimately functioned as a licensing program for him worldwide. So it was
yes.
a very interesting opportunity and outcome.
And I love that because again, that keyword licensing, this person taking that risk now sets them up for money in perpetuity. Also, I want to say this, just know, just because you're the first to try to do something, you could be opening the door for tons of other people, right? This person was just trying to protect their own idea, their own creative work, but they ended up opening the door for tons of other people to have that opportunity too. So sometimes it's not even just about you. You might be helping folks who you never even get a chance to meet years later. But your willingness to take that risk makes a huge difference. So I just had to say that. Xavier, go ahead.
Thank you. So one example that comes to mind is that, well, this person came to me as I think a referral through Reddit, which is interesting on regarding trademarks. So they already had another attorney handling their trademarks, so they got a likelihood of confusion office action, which is one of the most difficult things to overcome. For some reason, there was some type of discrepancy or issue with the other attorney that they decided to go with me, and I was able to overcome the likelihood of confusion office action, even though it was pretty close. So that's just one example. On the patent side, so I guess the essence of the question is like you have to have the right counsel to who can advise you and to, hey, look, these are the things that we can do. These are pitfalls. These are arguments that can be raised. This is a strong argument. This is not a strong argument because there's things that can be done, but you have to. It's more like an art. It's kind of creativity. So I do have another example if you want on the patent side.
No, go ahead. And I will make just a quick note with that. So, oh, let me see. I'm getting some echo. Where did it go? Okay, here we go. So, one of the things that I love about that story is that you mentioned this in art. So, yes, there is a science to this, meaning that there are legal terms, there are forms you have to fill out. That's the science part. That's extremely important, but it's also an art. So understanding and knowing little changes that you can make to increase the likelihood of success. And that is the part where legal partnership is important. Because again, I only know my stuff with this. I'm not an expert at this because I don't do it every day. Okay, that's it. Go ahead, Xavier. I'm done with my commentary.
I'm just quickly piggyback off of that because think of the people who are reviewing the applications. They are human beings. So you have to write in a way that is very clear and concise, and they can follow your logic, and also supported by what is in the trademark examining manual or in the patent examining manual. That hey, they have bosses, they have to look at the stuff too. So this is the reason why they made a decision to move rule your direction. So it has to be looked at that way. But on the patent side, there was a software application directed to product placement. So I was doing work for a company that did a lot of software drafting applications. And I got assigned this application, which is already in process. They got something called Section 101 rejection, directed to an abstract idea. So those are very difficult to overcome because there may not be enough. You have to prove that this is a tangible product or tangible application. So it depends how the application is drafted. It may not have enough to pull from it. So I was able to successfully navigate to actually pull information from the applications like, hey, this is how it's being applied. So that was very successful, which led to a registered patent.
Thank you so much for that, Elizabeth. And then Tara, you'll close us out on this question.
Happy to jump in on this one. And I love the examples that my fellow panelists have provided, particularly Stevens. I am fascinated by the non-traditional trademarks and love those ones that come in for scent, shape, color, sound. I'd love to see even more of those because I think they're just so inherently creative. I think where I've seen people be most successful, and hopefully this isn't an obvious answer, but one where people do it repetitively. And that's not to say that you can't be successful with one application, whether it's for a patent or a trademark. But obviously, the more we do something, the better at it we get. Think about when, as kids, we learned to ride a bike. The first few times we got on our bike, we probably ended up on the on the street, with a skin knee and in the ditch. But the more we rode our bike, the better at it we got. So certainly, our prolific inventors, our prolific filers, and this is where having the assistance of a trained IP professional comes in handy because they do this repetitively. So they know the process, they know the routes for success and how to approach the process. But even for individuals, the more you do it, the better at it you get. Second, I would say, and this is both with respect to patents and trademarks, is if you find yourself hitting a roadblock, not understanding an office action communication from the USPTO, call us. You can either call the patent examiner or the trademark examining attorney, or you can call our patent assistance center or our trademark assistance center. They are there to help you. They are there to help you walk through the process to understand the language. Now, if you're using an IP professional, the office is going to communicate with them versus you, the creator. But if you're doing it, going the road alone, the office will engage with you directly. Our statistics show that those patent applications in particular, where there is an interview held during the examination process, there's a greater likelihood that patent application will go to allowance. Because by having either a telephonic or a video call like we're having today, you can have actually, you and the patent examiner are no longer two ships passing in the night. You can actually have a robust conversation about what it is you have invented and what it is they think perhaps might be precluding you from getting a patent. And last but not least, I would say people I think that do it most successfully are people that don't take the process personally. Now, I know we've talked about optimism and believing in ourselves, but when I say don't take the process personally, I've seen all too many times, particularly individual inventors who get a communication from the US Patent and Trademark Office, and that communication says, we reject your claims, we object to your specification, we object to your drawings, all of which sound very, very negative. And they step back, they crawl into their shell, and they say, the patent office hates my idea. Well, that's not true. We don't view your invention personally. We view it from that legal and technical lens as a quasi-judicial official. So when we reject your claims or reject your specification or object to your specification, we are really beginning the process of communication and collaboration with you to arrive at the identification of patentable subject matter if it exists. So don't take it personally. Don't take these negative terms as something that is setting you aside and saying, no, not ever. We're just saying, no, not right now. We need to resolve some issues possibly in order to get you to a yes. The law dictates that inventors are entitled to a patent unless the US Patent and Trademark Office deems otherwise. So we start at yes. So let's look at it from that perspective. We want to issue you a valid US patent if you're entitled to one.
Tara, can I hop in for 1 second, real quick? Thank you so
Sure.
much for that last part, Elizabeth. That's so interesting because I think a lot of us, and some of it is, there's a little bit of fear interacting with government agencies, period, sometimes, just to be completely transparent. And so we do assume that we're starting at no and trying to fight to get to yes, instead of assuming it's a yes, but we want to make sure that we have everything in order. And I think that ties into what you said about kind of depersonalizing this legal process. Understand that the examiners are responding in the way that they are legally required, right? So they
Mhm.
can't tell you, oh, hey, I'm saying this because it's this. Thank you. Like they're your friend. They have certain legal and required language that they have to use for certain things. So, to Elizabeth's point, when you're having the conversation, that's when you can start to explain and really build that rapport. But if you're getting something on email, yeah, it's going to seem to us generic because we're not used to that language. And that's also why the legal partnership is really important. I have a personal rule, or really it's a professional rule that I use in my business. Anything more than 2 emails is a phone call. So if I
Mhm.
send an email, somebody doesn't understand something, and then they reply again, and we still seem to be confused, it's time to get on the call, whether that's
Mhm.
telephone or some type of video platform, because most things can be resolved in like 30 seconds instead of going back and forth with these long paragraphs. The same thing with the length of an email. If something is like more than 2 paragraphs worth of prose, not necessarily a bulleted list, but if I got more than 2 paragraphs, that's a phone call. And then I'll send a follow up email to say, hey, per our discussion when we talked, here's what I meant by blah, blah, blah. That has served me well in business in general. And especially if you're going at it alone in the process, which I would not suggest per all the discussions we've had in these webinars. But if you do go it alone, like Elizabeth said, those conversations can mean the world. All right,
Mhm.
Tara, I'm out of it.
Okay, well, Miss Elizabeth, your office did send me 2 office actions. And I was so happy to have the wisdom of my attorney because, again, when something is your baby, it's very easy to take something personally, and it is not personal. And to your point, when my attorney would come back and say, well, this is what the office is saying, I would actually take the critique and I would use it to develop. And when you guys saw me grabbing my phone, I actually put in my search office action to read through a couple of the office actions that I received and really looked at how I use those critiques or those insights to further develop my idea uh, even better than what it was. And so, for people listening in, I would say that criticism or critiques or additional wisdom, additional information is not meant for you to be offended by it. It's meant for you to grow. It's meant for you to make your idea even better than what it is. And so, that was an excellent point that you made, Elizabeth. It reminded me of my own journey. And on top of that, I just really want to say this is why it is so helpful to have an attorney, because if you are taking something personally, you probably are not the best person to pick up the phone and call the office. You're not going to help your cause, okay? And so, but having an attorney, and I know sometimes we hear the word attorney and we might become intimidated by that, but I always tell entrepreneurs that your vision, your dream is worth the investment. And so if you can afford to, save up money, put money to the side and get with the professional who knows what they're doing, it will save you more money than it will cost you. It will save you time. It will save you energy. And so I'm always going to advocate for entrepreneurs who don't have experience reaching out to the professional who does.
Thank you so much for saying that, because you're right. It is our baby, and we take, especially, it's that key word when you see reject words like that. It's like, what do you mean rejection? Like, I made this, but
Yes.
they're doing their
One
work.
of my responses to my attorney was, "Tell them people I'm on maternity leave." So
And it is interesting because for a lot of us, we are solopreneurs or operate
Mhm,
on very small teams. And
mhm,
so this becomes another task that we not only have to execute on, but figure out. And it will cause us to be emotionally overwhelmed.
mhm,
Have the right support, have the right partner, but recognize and know that you, as a small entity in number, are creating this amazing thing. And
mhm,
it is worth the time to build the right partnerships to do it well. Because to Tara's point, the critique that you're getting, guess what? That's probably going to help you with developing your operational
mhm,
processes for using this. Is going to help you build probably a better website so you can have a better
mhm,
specimen. It's
mhm,
probably going to help you build better, educational videos or whatever the case may be. As I filed my trademarks, I told y'all before, I got like 13. Every time it made me be so much more intentional about
mhm,
things. And even in some cases, I ended up folding certain businesses that I was trying to file trademarks for, because I was like, you know what, this really isn't worth it. Never mind. I want to do something else, right? So keep in mind that critique, it's like almost having an expert look over your work without it necessarily being called that. That when you get
mhm,
to the end of this process and you're successful, you have fleshed out probably every part of what you need to do for this idea, and
mhm.
that is priceless. So all right, let's
Absolutely.
do our final question. Here we go. And for this one, I actually want to start with Tara, because you mentioned about the office actions. How can we ensure that our research is thorough when looking for existing filings and registrations for similar IP, especially because for your business, it is a global entity. So, what
Mhm.
are some of the tips and tricks that you have for that research and search process, to make sure that we are doing our due diligence? So, we'll go Tara first, and then I'm going to go to Elizabeth, Xavier, and then Steven to close us out.
Well, I lived on Google. I mean, I did multiple searches on Google. I did searches, hashtag searches on social media. Those were the primary things, the two primary lenses that I looked through as related to my trademark of success bullying. And so I would just tell people that Google is at everybody's fingertips. At least show that you've done some type of research. So when you reach out to an attorney, you can say, hey, I don't see anybody else using this. I don't see this term being used anywhere else. And then also, when I went to purchase my domain name, that was also an indicator that my name was not in use, because that name was available, and it was not just available with .com, because I actually decided to do successbullying.us, a play on us, you see. And so I would say, when I did a domain search, when I locked down my domain name, Google and social media.
I'm gonna hop in real quick on that. Thank you for mentioning about domain name. That's actually one of the first ways, especially if you're filing under intent to use. That's one of the best ways that you can kind of get the um process of almost like marking your territory, because I
Mhm.
mentioned before, I think this was in the first one, I call them pirates, where they wait until people file because that's like public knowledge. And then they'll start scooping up domain names and almost like charging you a ransom. So I've seen that where sometimes you'll see a domain and it was free when maybe you first started the process, and then all of a sudden it's $6,000 to buy it, and somebody will send you a note. So be mindful of that. Usually, to get a domain name, if it's available, it's like $8, $10. Sometimes you would get them on sale for like $6, $7. That's one of the first ways that you can kind of mark that territory and protect it for when you want to use it later. So if you don't do anything else to start, perhaps maybe even before you secure an attorney, start with the domain name. Like Tara said, do a quick Google search. And then if you can just keep a document, a running document of like copies of what you found, when you go to work with your legal partner, you could say, hey, here's what I've seen so far to get started. I know you're going to do a much more thorough search, but I just want to let you know these are the actions I've taken so far. So thank you so much for that. All right, Elizabeth.
Well, I certainly echo what Tara said, and part of that is the use of Google and the use of any tool, any resource at your fingertips to access the known world, whether it's the known world of prior art for patents or brand registries and brand identifiers for your trademark. Um, and in doing so, to think broadly, and also goes back, Caitlin, to your considerations of your IP strategic plan and what it is you were trying to protect. So when I say broadly, I'll use the example of patent searching. If you've invented a new toothbrush, you're not just going to search the term toothbrush. You're going to want to think broadly with respect to the terms you use in doing your search. Oral hygiene tool, circular bristles, all of the words that you can think of. Don't just use the word toothbrush and see what pops up. Now, toothbrush would be a valuable term to use in conducting that search, but you've got to think even more broadly. This is where our patent and trademark resource centers that you referenced early on in our conversation and we spoke about earlier in the series. Our patent and trademark resource centers is a network of over 80 and now nearly 100 libraries that have at least one or more librarian trained in patent and trademark searching. These libraries are public libraries, oftentimes at colleges or universities, and these librarians are there to help you in establishing a high quality patent or trademark search. Now, they won't do the search for you, but they'll help lead you through the 7 steps of a successful searching process. So I strongly encourage the use of a PTRC librarian, or again, as we've talked about time and time again, an IP professional. Many IP law firms offer search assistance, either by the attorney, by a patent agent, by another member of their team. There are also patent and trademark search services. You can also take advantage of one of those. But again, bottom line, it's to think broadly. What types of classes of goods and services are you looking to protect with your trademark? What is it you are looking to protect with your patent? So think broadly, don't think too narrowly because you may be eliminating some of the prior art or brands that are out there that you should be looking at as relevant to what you're trying to do.
Thank you for saying that. Y'all know I got a comment. I got to make a comment about that because for one of the trademarks I filed, we found that someone had it on their website and they were fraudulently using the trademark symbol. Like they had it up probably as a deterrent, but they hadn't actually filed. So because I had a lawyer who was amazing, she looked it up. She's like, no, nothing was ever filed. Like it's not even something that was abandoned. Like it's just never happened. So I was able to make that filing. And this is where I want to caution you all to think business first, like Xavier said, because heartstrings me was like, oh yeah, but they had it on their website. So it's like, nope, they didn't file. Like that's not, they didn't take care of their business. And so you do have to be a little competitive with stuff, right? Because this is a business process, a legal process. So just want to just say when you're doing your research, you might find some surprising things. So don't be deterred because of what somebody might say they've done. The research is going to help you prove what people actually did and what they were successful at filing. So I'll leave that there. Xavier.
I'm gonna give some little golden nuggets. Are you able to hear me? Just want to make sure. So USPTO has a wealth of information on their website. Also, you could it's everything that's filed is public. So on the trademark side, if you see some type of trademark, you can go into the history and see what was the search strategy used by the examining attorney. On the patent side, you can also see what the search strategy was too. So if you want to really learn how to do searches, but this is a disclaimer, I recommend that you hire a professional. But if you're doing it yourself, think about from the trademark side, okay, how do they examine the application? One of the things to look at is likelihood confusion analysis. So when you're doing your search, you're actually looking through that lens when you come up with the results. So most people think about, is it an exact match? That is not the case. There's two factors: are the marks similar, and are the goods and services related? If those two things are true, you're not going to be able to get a registered trademark. On the patent side, there's search strategies, as Elizabeth was talking about. You have to think broadly because something might be like a toothbrush, but the terminology might be different because you have inventors have their own ability to be the write their own definitions essentially. So, like I said, the USPTO has a wealth of information. They have 7 strategies on how to do a search on the patent side, which talk about keyword classification and backwards and forward citation. On the trademark side, you could actually see the search strategy too. So, the little golden nugget.
All right, and we're gonna close out with Stephen.
So to piggyback on what both Elizabeth and Xavier mentioned, certainly the comprehensive databases out there are extremely important. USPTO certainly has it for patents. Google Patents is a good place, but when you go out and move beyond that, you might want to consider WIPO for international activity as well, because all of that can end up being prior art, and if so, it can be relevant. On the trademark side, of course, the test system, as Xavier mentioned, is extremely important for moving through the process. But WIPO's global brand database is also another one that is extremely important for international protection. When you put together these searches, certainly keyword searches, classification codes are very important. You need to really drill down into what might be relevant in other patents. Another nugget I think here is that when you start your search, particularly in the either trademark or the patent side, look at what those results are showing you. With that, you can probably filter down, be more precise in your search to get a better, more thorough search, which is really what the goal here is, right? You want to find out if there's anything that might prevent you or have some concern about moving forward, and you certainly don't want to waste any money moving forward in developing a brand or doing anything that might be, costly if you don't have the legal basis and status to be able to continue to do that moving into the future. And one other aspect here is also you don't want to infringe on anybody else's rights, because while you may not be in a situation where you can use the mark, you certainly don't want to be starting to use something that's similar enough where it can cause concern, and you'll end up in a situation where you can end up being on the receiving end of a lawsuit. So be very cautious in those regards as well, if that's helpful.
I just want to add one quick thing.
Of course,
On
go
the,
ahead.
on the patent side, make sure you document your search results, the documents that you come across, because you have a duty to disclose that to the USPTO. So just FYI.
And I'll just mention one other thing
Yep.
to piggyback even on that for some more nuggets here. Certainly, non-disclosure agreements and confidential disclosure agreements are extremely important when you start to talk with others about your trademarks, your inventions, anything, including your trade secrets. Trade secrets are another aspect of intellectual property that, while they don't have specific protection, the protection is in keeping it secret, and non-disclosure, confidential disclosure agreements can really be an assistance there as well. So hopefully that'll be a little bit more knowledge for the group.
No, I appreciate that very much. I want to make a note about that again because I know most people who are going to watch this call, they probably will be, again, either have very small teams or even be solopreneurs. Everybody should not know your ideas, right? And like, I know for a fact we hear this and see this all the time, but you need to keep it secret and safe. In my head, I heard Gandalf talking to Frodo Baggins on Lord of the Rings. It's one of my favorite movies. Like, keep it secret, keep it safe. Don't tell anybody about your ideas. I have business ideas that literally nobody knows, and this even goes for your staff. So, like, for example, I use Google Workspace. I have a shared drive for the company for like vendors, my operations manager, but then I have my drive. The initial ideas for anything I'm doing, it does not go on the shared drive. It goes in my drive, in a document, or on my computer until I'm ready to present it. Anytime I'm having conversations with folks about being a subcontractor, either where I'm subbing or they're subbing with me, we do an NDA first and foremost, and you should work with a lawyer to make sure you have the appropriate NDA for your state, your jurisdiction. All of that stuff matters because, like I was saying earlier, you can't have a bleeding heart in business. You don't have to be shady. You shouldn't be fraudulent, but you do need to be protective and territorial over what is yours. Because remember those whys: building generational wealth, scale into 7 and 8 figures, thriving in the knowledge economy. That requires you to be very thoughtful and intentional about who you share with and who you partner with. And that's another reason why we're suggesting having a legal partner, because once you go under contract with an attorney, that is a binding relationship where they are going to keep your information secret. You just asking, Jim Bob in random place online, hey, I got this idea. Can you tell me your search term? That person is not bound to keep your information secret. So again, be strategic in how you set that plan up, how you keep your information secret. Even thinking about, not necessarily doing your research on public computers. Use your phone, right? Use your computer at home. You might not want to use a public computer for that because somebody could come right behind you and see perhaps what was already in the search bar. So again, you do want to be very strategic. You want to be territorial and protective, and you want to be thorough. I am so grateful to our panelists today. This one was really good. I told y'all this third one was going to be good. So we are 3 down. We have 1 to go. The final session, and I've dropped the link to register in the chat. That one is going to be an open Q&A with about, I think we got 5 attorneys lined up, including some of the faces that you've seen in some of the other sessions, as well as my own trademark attorney. She is gracious enough to attend this final one. It is on January 22nd, same time at noon. I'm thrilled to have that. So if you have any questions at all, please be sure to drop them. Actually, you can use the form that's on my company's website. It's forwardcollective.com/support. So the number 4, WARD collective.com/support. And just drop a note in there with the questions that you have for the trademark attorneys. You can also attend and ask your questions live in the chat. As you all saw today, I was dropping some notes and responding. But we want to get your questions answered so that you can feel empowered to make better decisions in 2025. We starting this year off strong. We starting it off strong because we're protecting what matters, because we are determined to build our multi-million dollar enterprises this year, y'all. We can do this. Thank you again to the panelists. Happy New Year again to everybody that is watching. You can always check the replay on LinkedIn as well as my YouTube channel called the Fast Forward Podcast. Thank you again, everyone. Have a wonderful afternoon.
Thank you, Kaylin.
All right. Thank you all so much. I appreciate you. This was really, really good.